I've had the benefit of reading the judgment proposed by His Lordship B.R. Gawai. However, I wish to differ on the reasoning and conclusions arrived at in his judgment with regard to exercise of power by the central government under subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the Act for the sake of brevity, by issuance of the impugned notification dated 8th November 2016, hence my separate judgment. By way of preface, I state that the judgment proposed by His Lordship Gawai does not recognize the essential fact that the Act does not envisage initiation of demonetization of banknotes by the central government. Subsection 2 of Section 26 of the Act contemplates demonetization of banknotes at the instance of the Central Board of the Reserve Bank of India, hereinafter referred to as the Act, as the bank. Hence, if demonetization is to be initiated by the central government, such power is derived from entry 36 of List 1 of the 7th Schedule to the Constitution, which speaks of currency, coinage, and legal tender foreign exchange. I've quoted the 7 issues, judgments, which were, the references order dated 16th December 2016, where 9 questions were referred. His Lordship Gawai has reframed the questions referred to this Constitution bench and culled out 6 questions, which have been answered in the erudite judgment proposed by him. My views on each of such questions, as contrasted with those of His Lordship's, have been expressed in a tabular form hereunder for easy reference. It is at the head, I have put that. Then I have stated about the overview regarding the importance of the Reserve Bank of India and the Reserve Bank of India Act 1934. Then I have spoken about the history and instances of demonetization the world over, in France, in the United States of America, Britain, Congo, Ghana, Nigeria, Myanmar, Russia, Venezuela, Zimbabwe, and the history of demonetization in India in the 2 periods of 1947 and 1978. Then, while speaking about the Reserve Bank of India being the bulwark of the Indian economy, I have quoted Internet and Mobile Association of India versus RBI, wherein one of us, V. Ramsubrahmanyam J., while dealing with the regulation of cryptocurrency and virtual currency, highlighted the importance of the bank in the Indian economy. Then I've spoken about the economic and fiscal policies interference by the court and cited the judgments. What emerges from an understanding of the decisions referred to above or the subject of judicial review of economic policy may be culled out as under 1. That the court is not to sit in judgment over the merits of economic or financial policy. 2. That the scope of interference by a court is limited to instances where the impugned scheme or legislation in the economic arena has been enacted in violation of any constitutional or statutory provisions. 3. That the court may not undertake a foray into the merits, demerits, sufficiency or lack thereof, success in realizing the objectives, etc., of an economic policy. As such, an analysis is the prerogative of the government in consultation with experts in the field. Being mindful of the limited scope of judicial review permissible in matters concerning economic policy decisions, I shall limit my examination of the matter to such extent as is necessary for the purpose of determining whether the process concluding in the issuance of the impugned notification was correct or as being contrary to subsection 2 of section 26 of the Act and allied aspects of the case. It may be stated at this juncture that the said aspect of the matter is not one of form, but of substance. Therefore, examining this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization, and is therefore well within the limits of the Lakshman Rekha that this court has carefully drawn for itself. Then I have analyzed section 26 of the Act interpretation. There I have made again a table with a view to lend perspective to the issue with the discussion to follow. A bird's eye view of my analysis and conclusion has been expressed in a tabular form. The parameters for distinction, Then second, when the proposal for demonetization originates by way of a recommendation by the Central Board of the Bank. And the third is when the proposal for demonetization originates from the central government, as in the instant case. In that, I would say role of the central government, and the second parameter is role of the bank. The third parameter is extent of demonetization that may be proposed and carried out. Fourth, considerations for proposed measures of demonetization illustrative. Five, process or route to be followed to carry out demonetization. And six, applicability of subsection 2 of section 26 of the Reserve Bank of India Act. There I have stated that when the demonetization originates by way of a recommendation by the Central Board of the Bank, it is section 26(2) which applies. But when the proposal for demonetization originates from the central government, as in the instant case, it is not under section 26(2) of the Act. It is to be by way of a legislation. And if legislation is not the way, in the sense there is need for secrecy, then it is ordinance. Since I have accepted the contention of the learned Attorney General appearing for Union of India in relation to the power of the central government for initiating the process of demonetization, the next question would be whether the central government can, on initiating the process of demonetization, proceed to issue a gazette notification to demonetize any or all series of any or all denomination of banknotes on the strength of subsection 2 of section 26 of the Act. Consideration of this issue would also answer the contention of learned senior counsel for the petitioners regarding subsection 2 of section 26 of the Act being unguided and arbitrary in nature and hence unconstitutional. To this end, the following aspects have to be examined. A. Whether demonetization can be initiated and carried out by the central government by issuing a notification in the Gazette of India as per subsection 2 of section 26 of the Act. B. Extent of the central government's power to carry out demonetization, that is, whether all series of all denominations may be demonetized. As held herein before, the proposal for demonetization can emanate either from the central government or from the Central Board of the Bank. It is, however, necessary to contrast the proposal for demonetization initiated by the central government with that initiated by the Central Board of the Bank. When the bank recommends demonetization, it is, in my view, only for a particular series of banknotes of a particular denomination, as specified in the recommendation made under subsection 2 of section 26 of the Act. The word any in subsection 2 cannot be read to mean all. If read as specified or particular as against all, in my view, it would not suffer from arbitrariness or suffer from unguided discretion being given to the central bank of the bank. On the other hand, in my view, the central government has the power to demonetize all series of banknotes of all denominations if the need for such a measure arises. It cannot be restricted to such powers in such manner as the Central Board of the Bank is under the above provision. This is because such power is not exercised under subsection 2 of section 26 of the Act, but is exercised notwithstanding the said provision by the central government. Therefore, demonetization of banknotes at the behest of the central government is a far more serious issue, having wider ramifications on the economy and on the citizens, as compared to demonetization of banknotes of a given series of a given denomination on the recommendation of the Central Board of the Bank by issuance of a gazette notification by the central government. Therefore, in my considered view, the powers of the central government being vast, the same have to be exercised only through a plenary legislation or a legislative process rather than by an executive act by the issuance of a notification in the Gazette of India. It is necessary that the Parliament, which consists of the representatives of the people of this country, discusses the matter and thereafter approves and supports the implementation of the scheme of demonetization. The central government, as already noted, could have several compulsions for initiating demonetization of the bank notes already in circulation in the economy, and it could do so even in the absence of a recommendation as per subsection 2 of section 26 Act of the Central Board of the Bank. On its bank to demonetize the bank notes, the advice or opinion of the central bank, which has to be consulted, may not always be in support of the proposal of the central government, as in the year 1978. Central board may give a negative opinion or a concurring opinion. In either of the situations, the central government may proceed to demonetize the bank notes, but only through a legislative process, either through an ordinance followed by a legislation if the parliament is not in session, or by a plenary legislation before the parliament, and depending upon the passage of the bill as an act, carry out its proposal of demonetization. Then they have given the reasons for the same. And I've said why it should be through the legislative process. A parliament is often referred to as a nation in miniature. It is the basis for democracy. A parliament provides representation of the people of a country and makes their voices heard. Without a parliament, a democracy cannot thrive. Every democratic country needs a parliament for the smooth conduct of its governance and to give meaning to democracy in the true sense. Parliament, which is the center of our democracy, cannot be left aloof in a matter of such importance. Its views on the subject of demonetization are critical and of utmost importance. Nobody states that the impugned Gazette notification dated 8 November 2016 of the central government was published on the initiation of a proposal of demonetization by the Central Board of the Bank. Proposal for demonetization was initiated by the central government by a letter dated 7th November 2016, addressed by the Finance Secretary to the Governor of the bank. The central government, having obtained the advice of the bank on its proposal, proceeded to issue the Gazette notification on the very next day, dated 8th November 2016. The same was followed by an ordinance, and thereafter an enactment was passed. Then in the incident case, I've said whether the central board of the bank was in a position to visualize the objectives in the incident case. Under what circumstances the central government was consulted by the central board of the bank was consulted by the central government. Then deciphering the plain meaning of subsection 2 of section 26. I said the plain meaning has to be given to this provision. Then I have said that section 3 of the act, which was also in the clause 3 of the ordinance itself, is writ with inherent contradiction, because it says, notwithstanding anything contained in the Reserve Bank of India Act 1934 or any other law for the time being in force, and then says the 8th November 2016 notification issued under subsection 2 of 26. Section 26. Therefore, there is an inherent contradiction there in the provision itself. Then I have gone to the affidavits and record of the case, and the Government of India as well as the Reserve Bank of India, each of them gave 4 documents they have been looked into. And on looking into the records, I find that the use of the words or phrases such as desired by the central government had recommended the withdrawal of legal tender of existing 500 and rupees 1000 notes. Recommendation has been obtained, etc. are self-explanatory. This demonstrates that there was no independent application of mind by the bank. Neither was there any time for the bank to apply its mind in such a serious issue. This observation is being made having regard to the fact that the entire exercise of demonetization of all series of banknotes of rupees 500 and rupees 1000 was carried out in 24 hours. A situation where an independent authority such as the bank, based on its own appreciation of the economic climate of the country, recommends a measure to the central government must be contrasted with another situation where a measure which originates from the central government is simply placed before such independent authority for seeking advice or opinion on such proposed measure. Proposal of the central government on a certain scheme having serious economic ramification has to be placed before the bank to seek its expert opinion as to its viability of such a scheme. The bank as an expert body may render advice on such a proposal and on some occasions may even concur with the same. However, even such concurrence to a proposal originating from the central government is not akin to an original recommendation of the central board of the bank within the meaning of section 26, subsection 2 of the Act. Then I have gone through the affidavits of the Union of India and contrasted it with the affidavits of the bank. On a close reading of the notification dated 8th November 2016, in juxtaposition with the records, the following aspects emerge. One aspect of the matter which emerges with no ambiguity is that the proposal for demonetization originated from the central government by way of its letter addressed to the bank dated 7th November 2016. This aspect forms the central plank of the controversy at hand. That the recommendation did not originate from the bank under subsection 2 of section 26 of the Act, but was obtained from the bank in the form of an opinion on the proposal for demonetization submitted by the central government. Such an opinion could not be considered to be a recommendation as required by the central government in order to proceed under subsection 2 of section 26 of the Act. Even if it is assumed for the sake of argument that the said opinion was in fact a recommendation under subsection 2 of section 26 of the Act, in light of the interpretation given by me herein above to the phrase any series or any denomination, means specified series or specified denomination, the recommendation itself is void inasmuch as it pertained to demonetization of all series of banknotes of denomination values of rupees 500 and 1000. As has already been observed, the term any as appearing in subsection 2 of section 26 of the Act cannot be interpreted to mean all, as such an interpretation would vest unguided and expansive discretion with the central bank of the board, or the central board of the bank. Then legal principles applicable to the case, I have said that to do a thing a particular way or not to do it at all, that is Taylor versus Taylor, Nazir Ahmed versus King Emperor, and the various cases of this court on the said principle are cited. What emerges from the above discussion is that when a statute contemplates a specific procedure to be adhered to in order to arrive at a desired end, such procedure cannot be substituted by an alternative procedure which is not contemplated under the statute. Further, if an action is to be carried out by way of issuance of a particular statutory instrument on the basis of certain requirements, such action cannot be validly carried out by issuance of an instrument when the same is not contemplated under the Act. This is particularly so when the instrument enacted stands on a different footing than the one meant to be enacted. Then I have said something about the records. Hence, in my considered view, the action of demonetization initiated by the central government by issuance of the improved notification dated 8th November 2016 was an exercise of power contrary to law and therefore unlawful. Consequently, the 2016 Ordinance and 2017 Act are also unlawful. But having regard to the fact that demonetization process was given effect to from 8th November 2016 onwards, the status quo ante cannot be restored at this point of time. What relief may be awarded in the present case? In view of the above conclusion, the question of molding the relief shall now be considered. According to the petitioners, around 86% of the volume of currency notes of the total currency in circulation in the Indian economy was demonetized. They also stated that the people of India were exposed to undue hardship owing to the lack of financial resources and had to undergo not only a severe financial crunch, but were also exposed to other socio-economic and psychological hardships. The problems associated with the measure of demonetization would make one wonder whether the Central Board of the Bank had visualized the consequences that would follow, whether the Central Board of the Bank had attempted to take note of the adverse effects of demonetization of such a large volume of banknotes in circulation. The objective of the central government may have been sound, just and proper, but the manner in which the said objectives were achieved and the procedure followed for the same, in my view, was not in accordance with law, having regard to the interpretation given above. It has also been brought on record that around 98% of the value of the demonetized currency have been exchanged for banknotes, which continues to be legal tender. Also, a new series of banknotes of rupees 2000 was released by the bank. This would suggest that the measure itself may not have proved to be as effective as it was hoped to be. However, this court does not base its decision on the legality of legislation, weigh the effectiveness of such action in achieving the stated objectives. Therefore, it is clarified that any relief molded in the present case is divorce considerations of such success of the measure. Learned Attorney General, appearing on behalf of the Union of India, contended that the issues raised in these petitions have become infructuous and wholly academic, as the action of demonetization has been acted upon, and therefore the present cases are only of academic significance. It is necessary to examine the nature of relief that could be molded by the court in this matter. Thereafter, citing Bommai, Golaknath, Orissa Cement, etc., I have given my conclusions with regard to section 26(2) and the interpretation that it has to be through a legislative process. And in that summary, subpara 9, I have said the opinion of the Central Board of the Bank ought to be an independent and frank opinion after a meaningful discussion by the Central Board, which ought to be given its due weightage, having regard to the ramifications it may have on the Indian economy and the citizens of India, although it may not be binding on the central government. On receipt of a negative opinion from the Central Board of the Bank, the central government, which has initiated the demonetization process, may still intend to go ahead with the said process after weighing the pros and cons only by means of an ordinance and or parliamentary legislation, but not by issuance of a gazette notification. In other words, the central government in such circumstances cannot resort to exercise of power under subsection 2 of section 26 of the Act by issuing a notification in the Gazette of India as if it were exercising executive powers. Even if the Central Board of the Bank concurs with the proposal of the central government, the central government would have to undertake a legislative process and not carry out the measure simply by issuing a Gazette notification. In view of the aforesaid conclusions, I am of the considered view that the impure notification dated 8 November 2016 issued under subsection 2 of section 26 of the Act is unlawful. In the circumstances, the action of demonetization of all currency notes of rupees 500 and rupees 1000 is vitiated. Further, the subsequent ordinance of 2016 and Act of 2017 incorporating the terms of the impure notification are also unlawful. However, having regard to the fact that the impure notification dated 8 November 2016 and the Act have been acted upon, the declaration of law made herein would apply prospectively and would not affect any action taken by the central government or the bank pursuant to the issuance of the notification dated 8 November 2016. This direction is being issued having regard to Article 142 of the Constitution of India. Hence, no relief is being granted to the individual matters. In view of the above conclusions, I do not think it is necessary to answer the other questions raised in the reference order. Before parting, I wish to observe that demonetization was an initiative of the central government targeted to address disparate evils plaguing the nation's economy, including practices of hoarding black money, counterfeiting, which in turn enable even greater evils, including terror funding, drug trafficking, emergence of a parallel economy, money laundering, including hawala transactions. It is beyond the pale of doubt that such a measure, which was aimed at eliminating these depraved practices, was well intentioned. The measure is reflective of concern for the economic health and security of the country and demonstrates foresight. At no point of time has any suggestion been made that the measure was motivated by anything but the best intentions and noble objects for the betterment of the nation. The measure has been regarded as unlawful only on a purely legalistic analysis of the relevant provisions of the Act and not on the objects of demonetization. In view of the answers given by me to question number 1 of the reference order, I do not deem it necessary to answer all other questions of the reference order or even the questions reframed by His Lordship B.R. Gawai J during the course of the judgment, except to the extent discussed above. In the result, the writ petitions, special leave petitions, and transfer petitions are disposed of in the aforesaid terms. All pending applications accordingly stand disposed.